He has authored landmark judgments that shaped India's constitutional landscape from privacy to equality and to faith. Now, former Chief Justice of India D.Y. Chandrachud turns author with his new book, Why the Constitution Matters. In this exclusive conversation with the week, we will delve into his journey on the bench, the philosophy behind the Constitution, and the challenges of our democracy today. Welcome to the week, sir.
Thank you, Kanu.
Coming on to your book first. Why the Constitution Matters? Why did you choose to write now after stepping down?
When you're a judge, you spend your time resolving disputes between parties in the cases which come up before you. And I, of course, utilize a lot of my time away from the bench, as in the vacations, on some weekends, to talk to wider audiences. Because after all, when you speak through a judgment, you are addressing the facts of that particular case, and you are trying to resolve a dispute before you. When you write from the heart. When you speak from the heart, and you speak to a much wider audience, as opposed to just the specific parties before you. And I thought it's important to share my innermost thoughts, many of which were curated into speeches, with a wider audience to cover a wide canvas on societal issues, issues on the Constitution, and my vision on a good and humane and just society for the future.
So, if I want to take it further, is the Constitution to you is more of a legal text or moral compass for Indian democracy?
Well, at a certain level, it's a legal text. But to call the Constitution a legal text would really be only a very small part of the overall story, if I may say so, of constitutional history and the constitutional past, the constitutional present, and the constitutional future. First and foremost, it is a document for transforming society. And it's so many things really rolled up all into one. It was a document which evinced the transfer of power from a colonial regime to Swaraj, to a homegrown regime. But equally, it was a document which was adopted to bring about a social transformation in a society like ours, which was full of discrimination based on caste, discrimination on the grounds of gender, and to create a blueprint of what India should be in the years ahead. So, quite apart from this being just a legal text for lawyers and judges to interpret, it's a text which speaks to citizens, citizens who were there when the Constitution was adopted, citizens of the future, and in all, really, it creates a whole vision of which way a society should be molded to meet the challenges of the time, at that time and then in the future.
Right. So in today's political climate, which constitutional value do you see and do you think is most at the risk?
Let me say this, that we live in an age of technology. We live in an age of the social media. And the one thing which I think the advent of technology and social media has brought us is that people live in silos. They hear what they like to hear. People tend to see what they like to see. People tend to associate with those whom they want to associate with. And I think this element of diversity, which is so crucial to have a broad-based human experience, is seriously under challenge in the age of technology and the social media, which has increasingly brought us individuals into living in silos. Also, I do believe that what technology has done is, in its ability to convey ideas and thoughts across a multitude of people, as opposed to, say, the print media, what technology has done, therefore, is to have people to the ability to communicate to large volumes of people, large groups of people. And I think this element of living in society, living in a community where we accept each other for what we are, understand each other's perspectives, is something which is seriously in question all over the world. As you see recent events which are developing across the democratic and the non-democratic world.
Right. So, usually it is seen that children take inspiration from parents. But in your book, you have divulged that you have taken inspiration from your sons, Abhinav and Chintan. It's quite astonishing to read this part because parents don't acknowledge this fact so openly, but you have.
Well, I must tell you that in both in my introduction as well as in the acknowledgements, I have referred to the fact that I have taken inspiration from Abhinav and Chintan, because they are both prolific authors and speakers. And every time I read their latest book, I would say that, well, I have to make my debut at some point of time. And then the pressures of work really prevented me from doing that. So I think in that sense, they inspired me to write. Apart from Abhinav and Chintan, I've also referred to the fact that I had the good fortune over the last 25 years as a judge to be associated with young people who came and clerked with me, who were my interns. And I think, talking to people who are younger than me, especially the young, straight out of law school who came and worked with me for 2 years, was an enormously enriching experience. And so much of this book is inspired by conversations with my law researchers who would come and work with me. When work was done in the evening, we'd spend some time, discussing matters, small and large, important issues confronting our society. And I learned so much about life outside, because Kanu, one of the flip sides of being a judge is the isolation which it causes.
Right.
Because typically judges, at least I belong to the more conventional sort of judge in that respect, do not mix as much or socialize as much for reasons of preserving your own independence. But that also breeds a degree of isolation. And talking to these young people who come and work for you, who research for you, who share ideas with you, really is an eye-opener to the world outside and to how society is changing. And really their ideas ensure that I don't fall into intellectual disrepair, so to speak,
Right.
by continuously engaging with them.
Right.
And that was truly inspirational. And I'm very proud as a mentor to my law clerks that now all over the world, they are studying in the best universities, and so many of them are first generation lawyers who have now got scholarships. They've traveled to the best universities across the world and are doing brilliantly on their own. So it's a source of great pride for me as well.
Right, sir. So, in your farewell speech, you have once said that, the troll army will be not happy from the day because I'm now no longer on the bench. Do you still feel that the missing part, the trolls part, because you've been trolled constantly?
Well, I always look at the positives of life. Life is finite, whatever its length. And I think there's so much of good which you can do to others, and there's so much good that you can do out of a human life.
Right.
So why bother about the negatives? I just leave that alone.
Right, sir. So, looking back, which case has left the deepest personal mark on you as a judge?
I don't know whether I can identify one case which has left the deepest mark on me as a judge, because so many cases which sort of come into your court through the course of a judicial career do impact the way you are. But I think I wrote extensively on issues of gender and disability. So I think these are two areas where I wouldn't identify cases in particular, but areas. I wrote extensively on gender equality and on providing a dignified life to the disabled.
Right.
And just looking at these cases now in retrospect, I feel they really made a big impact, and they have made a big impact on my mind as well.
Right.
When I would have women officers from the Army, Navy and Air Force in uniform in my court during the course of the hearings, on the day of judgment, and then after the judgment came, they would they would smile and leave the court feeling that, well, their purpose, their mission was achieved, that the institution stood behind them. Or a young disabled student, say, seeking admission to a degree course in medicine, who realizes that, you know, she or he has got into college and their dreams will be fulfilled. So this brings a great deal of satisfaction to a judge. Of course, there have been cases which challenge you intellectually, in the sense that they're complex cases,
Yes.
complex in terms of law, but I'm not sure that that's what you're referring to. You're really referring
Yeah.
those cases which bring you a lot of emotive. Satisfaction.
Yes.
That's what really it's all about.
When you were at the bench also, you wrote about liberty and dignity. Yet activists like Umar Khalid or many other people like him are still in jail without bail. Has the judiciary failed to uphold its own principle that bail is the rule and jail is the exception?
Now look, Kanu, individual cases apart, on individual cases there could and is bound to be a difference of opinion.
Right.
But you have to look at the overall record of the judiciary. And you can't decide on whether, say, the Supreme Court is a pro-liberty institution based on a particular outcome which you agree or you disagree with. If you just look at the volume of cases which come to the Supreme Court every week in which bail is granted, that would be a clear indicator of the fact that the court does abide by the principle that bail is the rule and jail is the exception. Having said that, you know, ultimately it's for every individual judge to take a call on whether or not to grant bail in the facts of a particular case. Apart from the personal liberty of the citizen which is involved, there are other countervailing circumstances and factors which have to be borne in mind, which is firstly the seriousness of the crime, the impact of the alleged crime on society. The third, is there a likelihood of the accused fleeing justice or tampering with witnesses? I'm not dealing with the facts of a particular case, but there is also a societal interest in prosecuting crime. Now, it is ultimately for every individual judge to see where the balance has to be drawn in the facts of that particular case. Yes, society, people who comment on the work of the court are entitled to differ on the outcome of a particular case. But then it would be inappropriate, I feel, to pass a final judgment on the Supreme Court's role as a protector of liberty based on the decision in one case. For instance, during the years of the emergency, you had the ADM Jabalpur case,
Yes.
which said that in the course of an emergency, when at that time the right to life and personal liberty could be suspended, that the right to move the court for a writ of habeas corpus would also be suspended. ADM Jabalpur was overruled by us, my judgment in Puttaswamy's case. So you can criticize the judgment of the court, but then to use that one judgment and say this signifies the overall view of the court over a history of 75 years would be incorrect, because you'd have a series of judgments by the Supreme Court which have protected life and personal liberty. Finally, I must tell you that my own personal view is that, in particularly having regard to the presumption of innocence, that is, any accused is presumed to be innocent until they are established to be guilty. That presumption must lead to one basic principle, that ordinarily bail should be the rule, for the simple reason that you cannot keep an accused in jail indefinitely. What happens if the trial results in an acquittal? That person would have spent years in jail without any justification. Second, if there's no possibility of the accused, say, tampering with witnesses or fleeing from the cause of justice, there's no reason why you should keep our jails overcrowded with people. You can subject to them to conditions on travel abroad, on interfering with the fairness of the trial, so on and so forth. But I firmly believe that this message that bail is the rule ordinarily must also percolate down to the high courts and, more importantly, to the district courts, because it's of no solace to an accused that ultimately bail was granted by the Supreme Court, because between the time that a case comes to the district court and eventually goes to the Supreme Court, a huge time lag can take place. And if that person is granted bail by the Supreme Court, there's a clear reason why that bail should have been granted by the district court in the first place.
Right.
Why keep the accused in jail throughout that course of the period?
But why is the hesitation in the trial court or the high court, when a high profile cases reaches them, they still hesitate to pass a favorable order?
I'm not sure that's true about, say for instance, when you talk of high profile cases. High profile cases can have various meanings. It may be high profile from the point of view of the person involved. It could be high profile from the point of view of the crime which is involved. It could be a crime of money laundering. It could be a pure and simple crime under the penal laws. It could be a high profile in the sense it attracts a lot of public curiosity because of the nature of the person involved, an actor, for instance. So it's not correct to say that in all high profile cases that the trial courts don't grant bail. But yes, you are right to this extent that in the culture of distrust, should I say, which prevails at the present point of time, district courts are reluctant to grant bail. And for me now, as a citizen, someone who is no longer in office, as it was even when I was in office, this is a cause for very great concern. Now, what's the answer to that? The answer to that is really to focus more on the district judiciary. Too long we have focused only on the Supreme Court. We either praise the Supreme Court or we criticize the Supreme Court. I think it's important that we bring our focus to bringing about institutional reforms in the district judiciary itself. What happens is that district judges are subject to the superintendence and control of the high courts under the Constitution. And the district judges, and when I say district judges, I mean the hierarchy of judges in the district judiciary. People manning these courts are fearful very often of the consequences which may emanate if an order passed by them is reversed by the High Court. Very often you find that the superior courts pass strictures on a district court which has granted bail. Now, if you believe that bail was wrongly granted, a higher court always has the jurisdiction and the authority to reverse that order, to correct the error which has been caused. But then to cast personal aspersions on the district court is something which then casts a stigma on the judge, because the career of that judge is affected, their promotional avenues are affected. So it's important that we strengthen the district judiciary from the perspective that this message must go across to the district judges, that irrespective of what happens in the facts of a particular case, whether you are affirmed or you are reversed in appeal or revision, there would be no aspersion on that individual as a judge, unless you have concrete evidence to indicate that the grant of bail in a particular case was actuated by an improper motive. That's a different issue at all. That's a disciplinary issue. But I think it's important to strengthen the district judiciary and its institutional position in the hierarchy of courts, because citizens move the district judiciary as a court of first instance. And if the process of applying for bail before the district courts is going to be reduced to merely a mechanical exercise, just something you have to go through before you go to a higher court and get bail, that seriously affects the citizens' confidence in the legitimacy of court.
System now. It's often called it is opaque system. All closed door meetings happen and things like that. What do you think, in your view, its biggest flaw? And can it be fixed without giving control to the executive?
When you say that it's an opaque system and that is its basic flaw, I'm not asking you a counter question because I'm answering your questions.
No problem.
What kind of system would we envisage as a better system? When the collegium takes decisions on who should be appointed, say to the High Court, in the case of the High Court Collegium, or to the Supreme Court Collegium, or when the Supreme Court Collegium takes up, proposals for appointment to the High Courts, they are dealing with the careers of individuals, the personal lives of judges, the personal lives of those who are going to be asked to become judges, including the lawyers. Would it be good for the system that everything that is discussed is put out into the open? That would include, say, in the case of the appointment of a judge to the High Court, a lawyer's income, their personal credibility, their personal integrity, their relationships. It's almost like a 360 degrees analysis which is done while appointing judges to the high courts. Likewise, when you make appointments to the Supreme Court, you're also looking at people who are sitting judges, except for those who are from the bar, people who are sitting chief justices in the high courts, sitting judges of the high courts. Now, if you're going to start discussing all this in the public realm and to, video, say for instance, nobody expects that, but say to video record what's happening and put it out on social media, you'll be destroying the system because, you'll be affecting their credibility as individuals. So a lot of work which you do in terms of selection does involve issues of privacy, and which are not just matters between that individual and the system, but the system needs good judges, and to have good judges accept judgeship, you must therefore respect the right to privacy. So there is a countervailing viewpoint. I think therefore it would be wrong to say that this system is opaque. Should it be in the nature of an open court hearing? Obviously not. Should it be like an open parliamentary hearing? Obviously not, because our system is very different than say the US system, where they send appointments for the Supreme Court of the United States for confirmation hearings before the Senate. Our system is completely different. Yes, there are institutional reforms which can be brought about to render the collegium a better exercise in constitutional decision making. There's no denying the fact, but the question really is that what is the alternative system that we have? And any alternative system which has to be designed or conceived must ensure that you have a methodology which ensures that independent judges are appointed to judicial offices, that the process for appointment ensures that people of merit are appointed. Third, that you have a broad diversity of people on the bench drawn from genders, religious faiths, caste groups which are marginalized, so on and so forth. So I'm not saying that you have the best system in hand today. Obviously, any constitutional system is capable of improvement, but merely because it is capable of improvement, you completely discard that system. That's the question, and my answer is no. As you rightly said, you don't want a situation where the entire process of appointment is taken out of the hands of the judiciary and entrusted only to the executive. Will that necessarily produce an independent judiciary? Possibly not. And therefore, I think one answer, if we were to reflect on this, is to broad base the modalities for selection. Broad basing those modalities for selection, ensuring established parameters are applied, and then putting out into the public realm some basis for why decisions are made would go a long way in ensuring the public faith and confidence in the process, something which I had also followed, which is to put out on the website of the Supreme Court the reasons why we took a particular decision.
But now the resolutions are getting smaller, no reasons, nothing, only the names and all. What do you have to say about that?
I'll answer with what I did when I was in office, and which was that we made it a point to put out the reasons why we had arrived at a particular decision.
Right.
Obviously, as I said, what you put out in the public realm is what is relevant to the amount of disclosure which was required. I don't want to comment on what is done at present because I'm out of the system. It's very easy to criticize the system in hindsight when you have left office. I can tell you what I did, and I thought that was a good innovation.
So Justice Nagaratna recently dissented on Justice Pancholi's elevation to the top court, saying, he doesn't have that seniority as compared to the other candidates. But that was, not taken on record. I mean, since she was the only one amongst the 5 who said this. Do you think that, a lone woman judge that we have in the Supreme Court doesn't have that kind of say? And when we talk about that, we should have women judges, but we don't see anything reflecting.
When you say you think that the lone woman judge in the Supreme Court shouldn't have a say, there I have a point of difference with you. Whether you're a man judge or a woman judge, once you're appointed to the Supreme Court, you are a judge of the Supreme Court.
Sir.
So, whether a dissent is from a woman judge or a man judge shouldn't really make a difference. It has the same value as a dissent. Let's be very clear about that.
Right,
sir. Your gender makes no difference on the worth or the validity of your dissent. A dissent is a dissent, equally valid and equally to be respected, irrespective of the gender of the judge who is dissenting. Now, having said that, let's be clear about some of the basic principles. The work of the collegium is largely done on the basis of consensus. Though the work is done on the basis of consensus, there are times when the decisions of the collegium have to be arrived at by majority, which is something which is contemplated. Therefore, the very fact that one judge has dissented is not a ground in itself. I'm not dealing with the appointment of a particular judge because I don't want to enter into that that realm. As I said, it's easy for a retired judge to be, wise in hindsight. So I'm not going into the merits of a particular appointment, but looking at it from the perspective of principle. And which is simply this, that though ordinarily most views of the collegium are taken on the basis of an overall consensus, there are times when you take decisions on the basis of a majority vote. That happens in some exceptional cases. You'd probably be aware of the fact that when matters are discussed in the collegium, judges express their views freely, they talk to each other, they are heard by each other, and then a final decision is taken. The question as to whether a dissenting vote of a judge should be published and publicized, in the sense the fact that there was a dissent should be mentioned. I agree with you that you must mention that there was a dissent and leave it at that then. Because the fact that a view is not a unanimous view does not make it any the less valid as a view of the collegium. Just as in a judgment which you deliver, a judgment in a constitutional bench where there is a dissent by a colleague, that judgment doesn't render itself any the less a judgment of the constitutional bench because of a dissent.
Right.
Dissents are acceptable either on the judicial side or in your administrative functioning. But the fact that there is a dissent should be accepted, acknowledged, and shared.
Right, sir. So we still don't have a thing, despite you pushing for having more women judges in the system. We still not seeing that reflecting into the entire system, be it High Court, be it in Supreme Court also. What do you think? There is a systemic failure or something else?
First and foremost, let me begin with the district judiciary. Because as I said, there's too much focus sometimes on the Supreme Court, when really the base of the pyramid is the district judiciary. Today, across India, the statistics indicate that when fresh recruitments are being made to the district judiciary through competitive examinations, women are doing not just as well as men, but better than men. In many states, the recruitment of judges to the district judiciary at the lowest levels has about 60 or 70% women coming in. So that's a sign of the changing times. More and more women are joining law schools. More and more women are attracted to the law as a viable profession. and which is explained by the figures of more and more women joining the district judiciary. Now, over a period of time, these women will become, say, a young woman who becomes a junior civil judge today will then become a senior civil judge, an additional district and session judge, a district judge, aspire to come to the High Court. Some of them may come to the Supreme Court. That's the first part of the matter. High Courts, you'd see that there is a divergence in trends. Some states, number of women have been recruited as judges of the High Court from the bar. The reason for that is that there has been a spread of women's education in particular in those states, and as women have been educated in large numbers in those states, a lot of them have joined the bar. Now, one of the problems which women face when they join the bar is the level of attrition. As you know, familial responsibilities take over. A lot of women tend to drop out as you know they get into bearing children, looking after parents, looking after aged members of the family. That's part of our social structure. Now, how do we ensure that so many of the young promising women who join our judicial system don't leave the system over a period of time? I think when I say we, I say institutions. Institutions have a very vital role to play in this by ensuring that we create conditions of work which are hospitable to women. So, for instance, a woman who has just had a child and who is not able to come to court and spend the whole day sitting in court waiting for a matter to reach should be encouraged to argue on the basis of a video conferencing platform. I know of, as a matter of personal fact, that so many young women lawyers have come up to me and told me that, well, when I had a child and for those 3 or 4 years, I've been working principally through VC. That has aided my career, while at the same time, I have not been deprived of my work as a professional. So simple changes like this which institutions can make would contribute in a very large measure to ensuring that women do not fall out of the labor market in the legal profession just by virtue of the fact that they are bearing a greater share of familial responsibilities. When you come to the Supreme Court, the issue is this. Primarily, appointments to the Supreme Court are made from the High Courts. Though you have, of course, a few women lawyers who've also become judges of the Supreme Court, and women and men lawyers. But primarily, judges in the Supreme Court are drawn from the High Courts. Now, you can't pick out, just because you want to appoint a woman, somebody who is out of the zone of consideration, say somebody who is 25th in the order of seniority, because you're also dealing with the career prospects of their male colleagues. You're also appointing women because they are good. You're not appointing women judges to the Supreme Court because they are women. You're appointing them because they are good, they're experienced. They bring a value addition in terms of their lived experiences of life. As more and more women get appointed to the High Courts, first to the district judiciary, then to the High Court, we will automatically see an increase in the appointment of women to the Supreme Court. So to answer your question really, is there a systemic failure? I wouldn't say that it's a systemic failure, but I would say it's a product of not just the appointment process, but a much wider issue pertaining to the role of women in legal education, the conditions of work for women lawyers in the districts, in the high courts, encouraging women to continue to be in the legal profession through the entire gamut of their careers. So it's as much a social issue, as it is purely an issue of the appointment process.
Now coming down to the tenure of Chief Justices we have, do you think this undermines the judicial leadership because the short tenures doesn't give you that kind of edge, and should we rethink the retirement age or tenure length?
On short tenures, look, the reason why we appoint the senior most judge of the Supreme Court of India as the Chief Justice of India is to preserve judicial independence. That call has been taken by a convention which has evolved since 1950 to ensure that the appointment of the head of the institution in the Supreme Court, the Chief Justice of India, is not based on the fancy or the whims of the executive. Now the flip side of that, as you said, is someone may become a judge, a Chief Justice of India, as we've had in the past, for a month, someone for 6 months. Obviously, the point which you have made has a sense of a germ of truth in it, that appointments of Chief Justices for very short periods does not allow you sufficient time to create a blueprint for future leadership. But there's an answer to it, and which is collective leadership. A person who holds office as Chief Justice of India can be in very close contact, as we are, with our successors, so that where a Chief Justice is in dialogue with the successors to that office in the future, you would have a sense of continuity, where there would be, in that sense, a collective mission on what should be the path forward for the institution. This particular modality, which was adopted in India, was adopted for the reason of preserving judicial independence. How do you do that in a manner which would foster effective leadership? And I think that leadership could be fostered across various positions by successors working together in devising a common path for the way forward for the court.
Right. Being the son of a former CJI, did that make your journey harder or easier?
I think harder, because because when I joined the bar, my father had retired. One rule which my father had laid down was that I will not enter any court so long as he was a judge, because he said, I'm CJI, and every court, any court that you would enter would be a court which would be lower than me in hierarchy, than mine in hierarchy. So I joined the court effectively after he retired. Now, the reason why I said that my task was harder was for the simple reason that people would tend to equate me as a young learner with a learning license, just finding the ropes in the legal profession, with what my father was at the top of his career. Not realizing that, I had to stumble, make my own mistakes and learn from experience.
Right.
So I thought that was a huge challenge, to be compared constantly in my early years as a lawyer to a man whom everybody had come to regard as the leader of the Indian judiciary. That was tough. If you're asking me as to whether being a judge's son makes a difference, for me, the fact that my father had retired, by the time I became a lawyer, meant that I had to strike it out on my own. Yes, being from a legal family gave me a certain degree of, should I say, a greater access to people at the bar knowing me as an individual. But I don't think in the long run that makes a difference, for the simple reason that people give you work as a lawyer based on whether you're good or not. The fact that your father or your mother has been a judge may possibly open a door for your initial case, but beyond that, if you're not good enough, people don't brief you in the court. It's a marketplace of ideas and services where people who are competent ultimately would succeed.
But was it a laid down principle in your family? Because we've seen both of your sons who had very good practice, but wasn't available when you were at the Supreme Court. They are now regularly appearing before the top court.
No,
so
not
there is any
them.
Written rule or?
No, there is no written rule, and I don't want to say that there should be a written rule. It's for everyone to take a call. My younger son is a barrister in London, and therefore practices in London. My older son, Abhinav, has had taken a decision, and so had Chintan, my younger son. Both of them had decided that so long as I was a judge of the Supreme Court, that they would not enter the Supreme Court for legal work. That was the call which they made. I respect them for it, because that also meant that nobody could probably surmise or criticize them or me for the work which they were getting in the
Right.
Supreme Court. So none of them entered the Supreme Court for legal work of any nature whatsoever, so long I was as I was a judge of the Supreme Court or Chief Justice of India. That was a call which they took. I respect them. I'm grateful to them for having taken that call. I don't want to comment on what anybody else should be doing.
Right. Finally, when you say the Constitution matters, coming down to your book, who are you really speaking to? Judges, politicians, or citizens?
The citizens. Whether we are judges, whether we are lawyers, somebody is a politician, everyone is a citizen. And my book speaks to citizens. In fact, there's a chapter in the book on which the title is based, which is Why the Constitution Matters. And it tells the story of a very well-known scientist. And he had put up a horseshoe outside his home. So a colleague scientist came to his home and asked him, well, why have you put this horseshoe outside your home? Are you superstitious and you believe that the horseshoe would bring you luck? And he turned around to him and said, well, I'm not superstitious, but the reason why the horseshoe is up there is that I believe that whether or not you believe in it, it works. And I think that's what the Constitution is all about. Whether you believe or not in the Constitution works. And in fact, I end the chapter with that example. So the Constitution is for everyone. And this book, which I have curated and put together, is about the fact that the Constitution makes a difference in the daily life of every citizen. And the idea behind this book is to show every Indian citizen how the Constitution impacts every moment of their lives, from their privacy to their agency, to their dignity, to their life, to their personal liberty, and to their right to freedom of speech and expression.